The Supreme Court heard oral arguments this week in a pair of challenges to President Biden's student loan forgiveness plan, with the administration defending its policy to what appeared to be a skeptical majority of justices, as Chief Justice John Roberts questioned the president's authority to unilaterally wipe out nearly $500 billion in debt.
If you're talking about this in the abstract, I think most casual observers would say if you're going to give up that much amount of money, if you're going to affect the obligations of that many Americans on a subject that's of great controversy, they would think that's something for Congress to act on. And if they haven't acted on it, then maybe that's a good lesson to say for the president or the administrative bureaucracy, that maybe that's not something they should undertake on their own.
Let's bring in our panel: Wall Street Journal columnist Bill McGurn, columnist Alicia Finley, and editorial board member Kyle Peterson. So, Kyle, for your sins, you listened to that oral argument. So what were the big lessons you took away from it on where the justices are heading?
Well, a lot of the argument was about standing, whether the plaintiffs here have the right to sue, but I don't think that's what this case is going to be decided on. I think there's a majority of the court that will get to the merits. And there, I think it's interesting because President Biden has justified this under the HEROES Act. This was a bill passed after 9/11 and was essentially meant to hold people harmless for their student loans if they ended up serving in Afghanistan or something like that. And I think what the court seemed to be very interested in this idea of the major questions doctrine, which is that bureaucracies are not supposed to find some sort of small language that they can make a huge economy-wide decision based off of. As Justice Antonin Scalia once wrote, Congress does not hide elephants in mouse holes. And so I wouldn't be surprised at all if that's where the majority of the court ended up, saying essentially that the White House does not have the power to do this because Congress didn't clearly grant it.
Alicia, you've inspected the HEROES Act that they're relying on. What do you make of their argument that it's, I guess, about 20-year-old statute, that it justifies this large undertaking?
Well, as Kyle pointed out, this was a very discreet law that was intended to help military members who went to serve overseas and then had struggled to repay their debt when they came back. It has only been used in very rare cases to waive paperwork burdens for military members. And if you actually inspect the law, it applies to national emergencies and wars. But it requires that the members or people who are receiving a benefit actually be affected by a war or a national emergency. The issue here is for the administration, which is forgiving debt for about 40 million people, that they cannot show that those 40 million people have actually been financially or otherwise affected by the public health emergency. In fact, many are actually better off, according to New York Federal Reserve studies, than they were before the pandemic.
Interesting. Bill, that was quite a statement by the Chief Justice, thought sometimes to be a swing justice. But when it comes to regulatory overreach and limits on executive power, he's been pretty strong. I think he wrote the West Virginia v. EPA decision, if I remember properly, last year that stipulated that major questions doctrine. Am I right about that? I think I am.
Yeah, I think you're right. And also, it's pretty clear. I mean, did the authors of the HERO Act ever intend this? This is how government expands in ways that I think are flatly unconstitutional. I think the constitutional case is very clear, and also the political case is not that good either. President thought he could bribe young voters into supporting him, but a lot of people are saying, hey, I'm paying for that kid's college, and I didn't take out loans. I didn't go to a pricey school, and it's not working for him. And you know that it's not working because he didn't mention it in the State of the Union. If it was a good seller, he would have mentioned it.
Kyle, do you think they kind of know what's coming here? I mean, the Solicitor General who argued for the administration tried to limit the major questions doctrine to saying it doesn't apply in this case, but $400 billion sounds pretty major.
Right, and she tried to say that if an agency is doing a regulation that directly impinges on someone's freedom or their liberty, maybe the major questions doctrine, extra scrutiny is warranted, but not in this case where it's just about Uncle Sam writing checks. But I don't think the justices are going to take that bait. And remember, we're talking about hundreds of billions of dollars here, so I think that's major by anyone's definition. I think it's a huge case. I think President Biden probably knows what's coming. He's probably preparing to run against the court as an institution in 2024. He was probably going to do that anyway. And for all we know, maybe they are scouring the U.S. code looking for some other provision that can get them some of the way that they want anyway, because it does look like the Supreme Court is going to strike this down.
Briefly, Alicia, can you recall any case of this magnitude where a president could essentially appropriate that much money without Congress giving its own assent?
No, and it's funny because if you recall in the Trump administration, when President Trump used emergency powers to merely repurpose about $4 billion in defense spending to build his border wall, there was a huge outcry among the left and saying, well, he doesn't have the authority to repurpose just $4 billion. And here we're talking about $400 billion and actually up to $1 trillion by some estimates.
Yeah. Okay. Thank you all.